Hear ye, hear ye, hear ye. The Supreme Court of Mississippi is now in session. Chief Justice William Waller, Jr. presiding.
Please be seated. Madam Clerk, would you sound the docket, please?
2012, I added my 66 SC Rachel Circuit, David Chapman, Nathan Kern, Anthony Price, Cody Tate, Captain Robertson, and Aaron Brown.
All right, what says the appellants?
The appellants are ready, Your Honor.
Napoli?
State's ready, Your Honor.
Okay. I would like to make a few remarks before we start. Initially, I would like to compliment the appellants, the appellee, and the amicus for some excellent substantive arguments that were in the briefs. I want to preface that I appreciate the professionalism that was exhibited in the briefs. And with that backdrop, this morning, I don't want any political sound bites. I don't want any jury arguments. No grandstanding. No sniping. Does everybody understand? We will recess at 10:30. I want you back in your seats at 10:45. We will resume at 10:45, and we will recess at lunch at 12:15. Hopefully, we'll be finished. I want to say today there will be no decision announced from the bench today. Now, the issues today are legal that we're going to be addressing, primarily centered around the executive power or authority of the governor to issue a pardon. We don't want to limit anyone on the arguments they want to make, but I do not want any arguments that may be considered redundant or repetitive on the appellant side. Everybody got that? Okay, Mr. Fortner, you may proceed. Madam Clerk, you may be excused.
Thank you, Chief, Madam Justice, Mr. Justices. I started off with this case and it's sort of been more than even a whirlwind. It's more like a tornado in the last couple of weeks. But I have had originally a difficult time getting my head around this issue. The idea, for 30 years I have been a street lawyer and I take issues to court and I expect courts to make decisions about those issues. And the idea of a court being limited to make a decision is foreign to me. It's always been foreign to me. So when I got this case, I had to figure out what was going on with our Constitution. And so, of course, I tried to find out what Justice Etheridge said about it, because that's where I look when I think about the state constitution. And in 1920, Justice Etheridge said, "The governor has many questions to decide in the performance of his duties. His decisions on these questions are final and conclusive on the other departments of the government. For instance, he is limited in granting a pardon to such cases as where publications have been made for 30 days in a newspaper of the county, but his decision as to whether the publication was made is not open to judicial review." I will grant you that's a dissent, but that's a dissent by the premier constitutional justice in our history.
Did anybody else join that dissent?
Not that I know of, Your Honor, but 3 years later in Montgomery versus Cleveland, Justice Etheridge wrote the opinion that said almost the exact same thing. We do not go behind the pardon and look into what happened with Section 124.
Mr. That was not an issue in that case, was it?
That was not the issue in that case. 131 was the issue.
The issue in the Cleveland case was, matter of fact, it was agreed, as a matter of fact, that the publication was properly made, was it not?
That wasn't an issue, though, Your Honor.
But it was one of the agreed facts that was considered by the court in making its decision.
Absolutely.
And there was no footnote to that issue that this is not an important fact or of no consequence because of my prior dissent.
No, sir. There was not.
Mr. Fortner, let's assume that what you're saying is true, and further assume that a governor hypothetically pardoned someone under indictment and before conviction.
Yes, sir.
Would that not be reviewable by the court?
Yes. But the question there would be, how does it come to the court's review? What would happen, Judge, is that I would get charged with a crime. I would get indicted for that crime. The governor would grant erroneously a pardon to me before I was convicted. I would raise that pardon as an affirmative defense in my criminal prosecution, and a court, a circuit judge in the court where I'm being prosecuted would look at that and say, I can look at the face of this pardon and tell you this pardon is not valid. This pardon does not recite a conviction on it. If you look at the pardons granted in this case, on their face, on the four corners of every one of these pardons, they are valid pardons. They recite a conviction, they recite a date of conviction, they recite the name of the crime, the location of the conviction. They recite everything that needs to be recited under Section 124 on the face of the pardon. And you can look at those pardons and tell they're valid. And if I were pardoned for a crime before I was convicted, the judge could look at that pardon and see that and make a ruling on that. And that's what this line of cases says. That's what our precedent says.
Let's go back to Montgomery versus Cleveland, and Justice Randolph alluded to it came before the court on an agreed statement of facts, including which that on the 11th day of November 1922, that said petition for pardon filed and with publication properly proved was on file in the office of the governor of the state of Mississippi. And then the opinion went on to cite the sections that might affect the issue before the court, section 116, 124, which is the issue today, 128 and 131. But as I read Montgomery, the fact that on the issue of publication, even though it's cited, was not really an issue before the court. The issue was whether the lieutenant governor could issue the pardon when the governor was out of state.
I agree with Your Honor.
Did the fact that it had been, they made the reference that it had been published, did that have anything to do, in your opinion, with the court's decision?
No, sir. There was an agreed stipulation of facts entered into in Montgomery versus Cleveland. That was not an issue decided by the court at that time or spoken to by the court, as Justice Randolph has pointed out. The court didn't speak to that issue at all.
So, Mr. Fortner, the majority of the court has never spoken to this issue.
As far as the governor's pardon, I don't believe it has, Your Honor. There are other times this court has spoken to this separation of powers issue very specifically.
Now, if following your logic then and your argument, wouldn't Section 124's notice requirement be a nullity if we follow it to the follow you down this trail completely?
No, sir, it wouldn't. And let me point out to you the case of Hunt versus Wright, where the section of the Constitution. I'm sorry, Your Honor. In Hunt versus Wright, the court was asked to look at Section 68.
That's 1892 case?
Yes.
Okay.
And Section 68 reads like this, Judge. Appropriation and revenue bills shall at regular sessions of the legislature have precedence in both houses over all other business, and no such bill shall be passed during the last 5 days of the session. It's almost identical language to 124. No pardon shall be issued until. No such bill shall be passed during the last days. And the court in Hunt said, We don't look behind that. That's a procedural issue left to the individual legislators and their houses. We want them to follow that, but we're not going to look behind the bill. If on the face of the bill, both the President of the Senate and the Leader of the House, the Speaker, has signed the bill and the Governor has signed and approved the bill, then that's as far as we're going to go. That's as far as the court can go because of Section 1 and 2 of our state Constitution, which is the separation of powers provision.
Don't you think there are circumstances, though, where the courts would go behind the legislative act if, for instance, legislature passed a bill, let's say it was a hunting bill, and decided that only men could vote on it, and only allowed the male members of the legislature to vote on the bill and declared that it was passed in law? Don't you think the court could go behind that?
I think if you're talking about a substantive violation of a constitutional right, if you're talking about equal protection, Your Honor, I think the court can go anywhere it needs to go.
So the line would be where the governor or the legislature, in your view, the line would be where the governor or the legislature could be said to have violated someone's due process or equal protection rights, if that's the argument. If it's not a procedural or some other argument, if it's an argument that the governor or the legislature has violated someone's constitutional right, then in your view the court would be justified in going behind the act of the governor or the legislature.
Judge,
I suppose that's a question. Is that where you think the line is?
I'm hoping that's not a trick question, but I think there's a line somewhere, and I think the violation of a substantive constitutional right will allow the court to go where it needs to go. Yes, sir.
Absent that, though, the court, in your view, should not go behind the act of the legislature or the governor.
Yes, sir. And I don't base that view. I don't reach that conclusion lightly either. I reach it from reading our precedent. I reach it from reading these older decisions, Judge. And I know that they're old, but there is language in these decisions that is so eloquent in explaining the separation of powers that it can't be understated. I mean, there's no way to understate how eloquent these writers of these opinions were and how religiously they guarded and zealously guarded the separation of powers, but very carefully. I mean, they made decisions that were hard decisions. I mean, the first case of all...
Before you go to that, I want to go back to Hunt.
Yes, sir.
All Hunt said was that the court cannot look at how the bill ended up becoming an act. But certainly the court has a right, and Hunt states that, to look at the finished action. You would agree with that?
I agree with that, Judge.
And that it is always for the courts to ascertain what is the law.
I don't know that I can completely agree with the word ascertain.
Hunt states that. Hunt states it is for the courts, as questions arise, to ascertain what is the law.
I think that, yes, sir, I agree with that.
All right. Now, changing the focus a second from the governor, is it your position that the governor has the right to waive the requirement placed upon the convicted felon to publish?
It's my position. I'm sorry, I can't give you a straight yes or no answer because it's not that simple. It is my position, Your Honor, that the governor, as the chief executive, granted the power to pardon by Section 124, is the judge of the propriety of the publication provision.
Based on the dictum in the Metz case?
No, not just based on the dictum of the Metz case. Based on Hunt, Your Honor, and based on X-ray Wren back in 1888, when the same Wren was in jail. Wren was charged with a crime that the legislature had amended the bill, and it wasn't a crime anymore. But unfortunately for Wren, that amendment didn't get into the finished bill. Even though, if you went behind the legislation and looked at the journals of the legislature, it clearly showed that amendment was voted on by both houses, approved by both houses, and should have been in the bill. But the bill was signed by the President of the Senate, the bill was signed by the Leader of the House, the Speaker, and the bill was signed by the Governor. And the Supreme Court looked at it and said, we cannot go behind this bill. On the face of this bill, it is valid law. And that's ascertaining the law. That's how far the court can go to ascertain the law.
Now, the Wren Court also said that the duty of this court begins when the act of the legislature is completed.
Yes, sir.
If we find that the act of the governor was completed upon the issuance of the pardon, wouldn't we then have judicial review?
I'm not suggesting that you don't have any judicial review, Your Honor. What I'm suggesting is that your judicial review ends on the face of the pardon if the pardon on its face is valid. And the pardons on their faces in this case are valid. That's where judicial review has to stop because of the separation of powers.
But the pardon in one of these other instances mentioned under 124 for treason, which requires the governor to run past the Senate. If there was a dispute on the Senate vote, it was 27-25 not to approve it, and the governor went ahead and issued a pardon, and on the face of it, it says you have a pardon. So we couldn't go behind that and look to see.
Your Honor, on the face of that pardon, I would suggest to the court that on the face of the pardon for treason, I don't know that we've ever done that here, but if that happened, it would have to note the consent of the Senate on the face of the bill. I'm not suggesting that you approve a fraudulent pardon. I'm not suggesting that at all. But in this case, and in the case you've outlined, the consent of the Senate would have to be on the face of the pardon. It is a constitution. Section 124 gives the legislature specifically the power to review a pardon for treason. It doesn't do that on the publication provision. It doesn't give the power to the legislature, the power to the Attorney General, or the power to anybody to review that.
That was going to be my next question regarding the fact that if you look at the part of the Constitution of Section 124 regarding in treason, the Senate has to confirm or whatever the language is or consent, whereas when in all other cases of pardons, applications or otherwise, there's no reference to legislative review or judicial review. Is that significant to you?
It is to me, Your Honor, for that reason. As far as the separation of powers is concerned, as far as that concept is concerned, Section 124 speaks to that directly. It gives another branch of government, specifically the power to review the executive's action in a treason case. It specifically gives them that power. It gives them that power in a remediature of forfeiture. They have to consent to that if the governor is going to do that. But that's it. That's where the separation of powers is finished in this Section 124.
But it doesn't say there, although the advice of the Senate is required, that the courts can review whether that was done or not. It's not explicit in that grant of authority.
But I suggest to you that if you are shown a pardon that doesn't on its face show its validity, then that pardon can be, you can rule on that pardon. You can say something about that pardon. I think you're obligated to.
Well, I'm looking at a 1924 case, and I don't think it was cited, called Grantham versus Wilkes. Are you familiar with that case?
I am not, Your Honor.
All right, Grantham versus Wilkes would be 1 year after Etheridge wrote Cleveland.
Yes, sir.
And it says, Section 124 of the Constitution requires all petitions for the pardon of a felon to be published. Now, that's the same court we're talking about that wrote the Mets, that wrote Cleveland, and then come back and then wrote this, and there's no dissent to this statement. Although that was not the issue in the case, this involved a libel case against the Daily Herald down on the coast, where an individual published his petition for pardon, and another fellow sued him because accused him of stealing 2 cows. And the court addressed and said Section 124 requires that to be published, and therefore that's a privileged communication, not subject to libel.
Your Honor, requirement, provision, however the words are stated in Section 124, I've still got to go back. I've got to get some guidance somewhere in our precedent. And if you go back to Hunt versus Wright, they say, while the provision of Section 68 is obligatory, which I think means required, on the legislature, its disregard of it is beyond the reach of courts, which are not keepers of the consciences of the legislators and deal only with what they do and not what they should have done or omitted. Now, I don't know any better way to explain the separation of powers in the context in which you're asking me than that. There may be something obligatory, but somebody is charged by the Constitution, by that section, with making that call. And Section 124 charges the governor, the chief executive, whoever it may be, with making that call. It doesn't charge...
Making the call.
Am I satisfied with the publication requirement or provision?
That's not what I understood you to say, Ms. Fortner. I thought you were making the argument that even if the governor didn't take the position that publication was made, if the governor took the position that I granted a pardon and there was no publication at all, I thought you were taking the position that even though that constitutional requirement was not met, that it's not open to review.
I am, Judge.
So it's not a question then of whether the governor is the judge of the appropriateness of the publication. In your view, as I understand it, you're saying that it doesn't matter whether the publication was appropriate or not, or was proper or not. It's not open to review.
I think that's correct. I think it's not open to. I think that section of Section 124 is not open to judicial review. Yes, sir. If you've got a pardon valid on its face, signed by the governor, which you have in these cases, and enrolled with the Secretary of State, attested to by him, and which all were introduced into evidence at the lower court's insistence, and they're authenticated.
But you're saying that the court should not even ask the governor, do you take the view the publication was appropriate? It's not our place or any court's place to ask the governor or anyone else's place. It's the governor's decision as to whether or not the requirements have been met, and if he concludes or she concludes that the requirements have been met and issues the pardon, that's the end of it. And whether or not publication was made or proper or too late or not enough is something we're all left to wonder about, but we have no forum to ever ask the question.
That's what I think our case history says, Judge. Yes, sir. Exactly that.
Let's go back to Hunt versus Wright and what Chief Justice Campbell said, and I want you to apply this language to today's case. And it's page 610 of the decision. Chief Justice Campbell said, every act which bears on its face evidence of disregard of the Constitution invites and must receive the condemnation of all who are called on to deal with it, and that is the test. Now apply that to today's case, if you will.
I don't have a problem with the Chief Justice's opinion on that, Judge. And if you look, what I'm saying is, if you look at these pardons on their face, they comply with the Constitution, they comply with the law, they are duly signed by the governor and granted by the governor, who has the exclusive authority to do that. If you look at these on their face, you've got a valid pardon.
The governor issued a pardon that pardoned someone, for instance, if we had a governor that didn't believe in the death penalty, and the governor pardoned everyone who got the death penalty from now for the next 10 years, your position would be that those pardons would not be valid on their face because they pardoned someone who is not even yet convicted.
Yes, sir, those are not, yes, sir, they're not valid on their face. The pardon has to be for a conviction.
Okay.
That's the requirement.
Mr. Fortner, who is the benefit of the publication for? Is it for the governor in your position? Is it for the people of Mississippi?
I can't definitively answer that question, I'll be honest with you. And reading through all these cases, I don't know the answer to that question. I think the idea was probably a joint. I think it was to inform the public. I think it was to let the governor receive comments if he wanted comments. But the bottom line is, everybody in the world can comment about a pardon, but it doesn't have to make any difference to the person authorizing it.
So the governor,
Power to authorize it.
so the governor today, for example, if there was a budget crisis and he wanted to release everyone convicted, perhaps of simple possession, he could just issue hundreds of pardons without referencing the notice provision at all.
Now, I do believe that, Judge. I believe the governor has the power under our Constitution to reach his hand into prison and pull out a handful of people and pardon them. Yes, sir, I do.
Why in the 1832 Constitution had no provision for notice, public notice, did it?
No, sir.
In 1869, it had no provision for public notice.
As far as I know, it did not, Judge.
And before the power to grant a pardon, that vests with the people unless they decide to give it to somebody else.
Yes, sir, but that's true of all the powers granted by the
And so
Constitution.
then the people vested in and decided in 1890, we will grant the governor the authority, will vest that authority in him, but they conditioned it upon publication in the 1890 Constitution, which was not in the prior constitutions, did they not?
That's correct, Your Honor.
So there's a limited power conditioned upon an act of the convicted felon to publish, which we all assume is for the purpose of public discourse. None of us know for certain.
Yes, sir, but on a condition that only the governor can decide whether it is satisfied or not. It doesn't give, Section 124 does not give the court or any legislative body or any other branch of the government the authority to make a legislation, to make rules about that section of 124.
But can't we go back to Marbury Madison for the proposition that it's upon the courts to determine if a constitutional provision has been met or if it's valid?
If you've got a justiciable issue, perhaps. But in this case, I'm suggesting that this is not even justiciable. This is an issue that it does not affect a substantive constitutional right of anyone. It is, at best, a notice provision. It is not mandatory, and it is subject only to the approval of the executive.
All right, give me one case that says it's not mandatory, where a majority of this court has determined that the necessity to publish is not mandatory.
I don't know, Judge. I can't give you that case. I don't know that case.
So that would make this a case of first impression.
I think you're dealing with a case of first impression as far as a pardon in Section 124 is concerned. I don't think you're dealing with a case of first impression as far as this separation of powers issue is concerned, because every one of our decisions has been consistent on that, and I've got to go back to Wright and Hunt and tell, while the provision of Section 68 is obligatory on the legislature, its disregard of it is beyond the reach of the courts. That's on page 610, first column, all the way at the bottom of Hunt v. Wright, Judge. I mean, this is an obligatory shall until...
Mr. Fortner, your time is out. We need to answer the questions, but we need to limit it to that.
I understand, Your Honor. Thank you.
Mr. Chief Justice, Madam Justices, and Justices. My name is Charles Griffin. My co-counsel, Barney Robinson, and I appear here before you as counsel for the former Governor Haley Barbour as amicus curiae. Ladies and gentlemen of the court, I submit to the court that this case is not about Haley Barbour. This case is not about General Hood. And this case is not about the individuals who have received pardons. This case is about separation of powers under the Mississippi Constitution. To the extent that the court will permit me, and for the sake of limited time, I won't readdress the factual issues that have been addressed by Mr. Fortner, but I will address any factual issues that are in the record that the court would like me to address. The first proposition I'd like to present to the court is that the governor's decision on Section 124's 30-day publication provision is simply not open to judicial review.
You state on the first page of your brief that what Mr. Fortner was talking about, the language in the Metz case was different